Chapter XIV. Intention, where there is an actual intent to defraud. No form in which the transaction is put can shield the property so transferred from the claims of creditors. Chief Judge Ruger in Billings v. Russell, 101N. Y 226, 234, SS 196. What is intention? Further space cannot be devoted to the discussion of the practical details of procedure in creditors' suits and proceeding. Let us next direct attention to a more complete consideration of the general principles and theories of law which these various remedies are devised to render effectual. The rules of evidence, which, as will appear, constitute a most important branch of this subject, will then be noticed in a general way. First, what is the fraudulent intent? Under the statute of Elizabeth, which must ordinarily exist to enable a creditor to defeat the debtor's alienation, 1 Sutherland, J. in Babcock v. Eckler, a case already cited, used these words. Intent or intention is an emotion or operation of the mind, and can usually be shown only by acts or declarations. And as acts speak louder than words, if a party does an act which must defraud another, his declaring that he did not by the act intend to defraud is weighed down by the evidence of his own act. Fraud, it must be noted, does not consist in mere intention, but in intention acted out, or made effectual by hurtful acts, in conduct that operates prejudicially upon the rights of others, and which was so intended. A fraudulent purpose is an important element in the case, but it is not the only essential requisite. There must be superadded to it, besides the sale or transfer, actual fraud, hindrance, or delay resulting therefrom to the creditors. While it may possibly be true that the impressions, emotions, or operations of the mind are never effaced, yet they can be reproduced only by the person whose mind gave them birth. Their true nature can only be determined or guessed at by other persons from the color of the outward acts which the emotions inspire. Hence the court, as we have shown, will not be concluded by the statement of the debtor's mental operations, for he is usually an interested party, nor will it accept his standard of morality as its test. In Potter v. McDowell, this language is used when a voluntary deed is made by a debtor in embarrassed circumstances, and a question arises as to its validity. In order to render the deed fraudulent in law as to existing creditors, it is not necessary to show that the debtor contemplated a fraud in making it, or that it was an immoral or corrupt act. The law does not concern itself about the private or secret motives which may influence the debtor. He may believe he had the right to make it, and that it was his duty to do it. Yet if the deed is voluntary, and hinders and delays his creditors, it is fraudulent. It may be observed here that a conveyance is fraudulent if the grantor meant to hinder or defraud any of his creditors, and a charge conveying the idea that he must have meant to defraud all his creditors is misleading. Also that it is not necessary to show that the fraudulent intent constituted the sole purpose, but only that it constituted a part of the purpose and design with which the scheme was entered into. If it is a part of the scheme to hinder or delay creditors, the whole transaction is void. The intent is the essential and poisonous element in the transaction. It must be borne in mind that an intent to hinder, delay, or defraud is sufficient to avoid the sale. It is not essential to show a union of these elements, though it must be conceded that it is not an easy task to distinguish between an intent to hinder and an intent to delay. SS 197. Actual intent not decisive. The question of the donor's actual intent is not then necessarily decisive. A man may give his property to his wife or children in the belief that he has the right to do so, but if by so doing his existing creditors are hindered or delayed, the conveyance will be set aside. In Briggs v. Mitchell, the court said, the property conveyed to the wife so far exceeds in value the amount of the money which it was conveyed to secure. It is of itself sufficient to authorize the holding that the conveyance was fraudulent as against antecedent creditors, without the finding of actual or meditated fraud. In Lukens v. Aird, Davis, J. said, it is not important to inquire whether, as matter of fact, the defendants had a purpose to defraud the creditors of Aird, for the fraud in this case is an inference of law, on which the court is as much bound to pronounce the conveyance in question void as to creditors, as if the fraudulent intent were directly proved. An act innocent in the intention may be so injurious in the consequences that the law declares it to be a fraud and forbids it. That the debtor made the conveyance to avoid the plaintiff's claim because he did not believe it to be just will not sustain the transfer. This subject has already been discussed. SS 198. Fraud of agent binding upon principle. Warner v. Warren establishes the principle that actual fraudulent intent, sufficient to avoid a transfer, need not be personal to the debtor. In this case, a husband obtained a power of attorney from his wife authorizing him to transact business as her agent. By means of false statements, he established a fictitious credit for her, incurred liabilities in her name, and then induced the wife to make an assignment. The wife was a guileless, artless woman who took no part in the business and intended to commit no wrong, but was a mere passive instrument in the hands of her husband, by whom the frauds were perpetrated, in avoiding the assignment in favor of an attaching creditor. Grover, J., said that the husband's objects became hers, his frauds were her frauds, and she is responsible therefore, however destitute of any knowledge thereof. This case is a valuable precedent, showing that intent may be established by implication or substitution, and that mental operation or emotion is not necessarily the test. SS 199. Mutuality of participation in fraudulent intent. Generally speaking, to render a conveyance fraudulent and voidable as against creditors, there must have been mutuality of participation in the fraudulent intent on the part of both the vendor and the purchaser. In discussing this subject, Chief Justice Church used these words: "Nor is the vendor's fraudulent intent sufficient. The vendee must be also implicated." So in another case it is asserted that in order to set aside as fraudulent against creditors a conveyance to one creditor, he must have participated in or have been cognizant of the grantor's unlawful motives when he accepted the conveyance. In Pruitt v. Wilson, Field, J. observed, when a deed is executed for a valuable and adequate consideration, without knowledge by the grantee of any fraudulent intent of the grantor, it will be upheld, however fraudulent his purpose, to vitiate the transfer in such case. The grantee also must be chargeable with knowledge of the intention of the grantor. It is even held in Dudley v. Danforth, by the New York Commission of Appeals, that where a vendee purchased property solely with a view of receiving payment of an honest debt, an intent on the part of the debtor to hinder and defraud creditors would not affect the vendee's title, although the vendee had notice of the intent, provided he did not participate in it. This would seem to justify action on the part of a creditor by means of which the debtor could be deluded and a preference gained by the creditor vendee. SS 200. Intent affecting voluntary alienations. The rule is to intent involuntary alienation, as we shall presently see, necessarily differs from cases where a valuable consideration is present. In the latter class of cases, mutual participation in the fraudulent design must of course be established. Where the alienation is voluntary, the invalidity may be predicated of the fraudulent intent of the vendor without regard to the knowledge or motives of the vendee. In such cases, the vendee is, of course, cognizant of the fact that nothing was paid for the property. The cases relating to this branch of the inquiry are reviewed by the Supreme Court of Maine in Lafton v. Hardin, an important case from which we have already quoted. Judge Story thus states the rule borrowed from the civil law by both the common law and the courts of chancery. Hence, all voluntary dispositions made by debtors upon the score of liberality were revocable, whether the donee knew of the prejudice intended to the creditors or not. SS 201. Of intention where consideration is adequate. The rule that a voluntary conveyance of property by a debtor may be annulled at the suit of creditors seems to commend itself as being both necessary and reasonable. The theory of the law is, as we have observed, that the debtor's property constitutes a fund upon which the creditors are supposed to have relied in extending the credit, and to which they are entitled to resort for payment of their claims. The plainest dictates of common sense and the simplest principles of justice require that any depletion of this fund should not be permitted in favor of a voluntary alienee. In cases where creditors remain unpaid, Chief Justice Shaw said, in a voluntary absolute conveyance, the fact that no consideration is paid is, of course, known to both parties, if the grantor was in debt at the time. As such conveyance must necessarily tend to defeat the rights of creditors, and as all persons are presumed to contemplate and intend the natural and probable consequences of their own acts, the conclusion is irresistible that such conveyance was intended to defeat creditors, and is therefore fraudulent. A different question, however, is presented where full pecuniary consideration has been paid by the purchaser. Can the transfer be nullified in such cases? And if so, in what instances and upon what theory? The answer is that, generally speaking, a debtor's conveyance can be set aside where it is made with a mutual fraudulent intent to hinder, delay, and defraud creditors, and that adequacy of consideration will not save it. In this class of cases, the question of intent becomes prominently material. Lord Mansfield said, in discharging a rule for a new trial in Cadogan v. Can it, if the transaction be not bona fide, the circumstance of its being done for a valuable consideration will not alone take it out of the statute. I have known several cases where persons have given a fair and full price for goods, and where the possession was actually changed, yet, being done for the purpose of defeating creditors, the transaction has been held fraudulent, and therefore void. The several cases of which this learned jurist had knowledge, where conveyances founded upon adequate consideration had been overturned by reason of the bad faith of the participants, have grown to thousands, and the subject has become one of vital interest and paramount importance, that a conveyance, whether it be of real or personal property, founded upon adequate consideration, may be vacated for fraud, is established in an endless variety of cases, a few only of which we will cite, in Wadsworth v. Williams, Hoare, J., in delivering the opinion of the Supreme Court of Massachusetts, said, "A conveyance made with an actual purpose and intent to defraud creditors, present or future, is not valid against them in favor of a grantee who participates in the fraudulent intention, although made for a full consideration, and by a grantor in the possession of any amount of property." The learned Chief Justice Black observed, "If a debtor, with the purpose to cheat his creditors, converts his land into money, because money is more easily shuffled out of sight than land, he of course commits a gross fraud, if his object in making the sale is known to the purchaser, and he nevertheless aids and assists in executing it. His title is worthless, as against creditors, though he may have paid a full price. But the rule is different when property is taken for a debt. One creditor of a failing debtor is not bound to take care of another. It cannot be said that one is defrauded by the payment of another. In such cases, if the assets are not large enough to pay all, somebody must suffer. It is a race in which it is impossible for every one to be foremost. It matters not what price was paid, or how early after the sale possession was changed, or how notorious the transaction was. If the vendor made the sale in order to defraud his creditors, and the vendee purchased with the design to aid him in the perpetration of the fraud, the sale is no more valid or effectual against such creditors than as if no consideration had passed. The right of a debtor, even in failing circumstances, to prefer a creditor, or to sell and dispose of his property in good faith and for value, to whomsoever he wishes, is generally unquestioned in the courts. Thus, the intention to defeat an execution creditor will not render the sale fraudulent if it was made for a valuable consideration, and is bona fide and absolute. So a confession of judgment with intent to give priority is valid. The transfers which we have instanced as objectionable are those which are merely colorable, or in which some secret right, benefit, favor, or interest is reserved to the debtor, or some unusual incident attends the transaction, stamping it as being out of the ordinary course of business, and as having been contrived to hinder, delay, or defraud creditors. Payment of the consideration is often in such cases a part of the scheme to more completely cover and conceal the fraud. Hence it is said that it is not the consideration, but the intent with which a conveyance is made, that makes it good or bad as to creditors. In Jones v. Simpson it was said that where bad faith in the vendor appeared, the burden was cast upon the vendee to show consideration, and this being established, the creditors must assume the burden of attacking the vendee's good faith. This seems to state the rule correctly, but general expressions to the effect that proof of bad faith in the vendor throws the burden of establishing both consideration and good faith upon the vendee are frequently encountered in the authorities. SS 202. Intention to defraud subsequent creditors. We have elsewhere seen that, generally speaking, a voluntary alienation is, as to existing creditors, presumptively fraudulent, but, as to subsequent creditors, a fraudulent intent must be proved or established, while a conveyance made to defraud a subsequent judgment creditor is within the statute. It seems to be laid down in some of the cases that subsequent creditors can only avail themselves of the fraud which is practiced against them. In Simmons v. Ingram the court said, to make a deed void as to subsequent creditors, there must be proof of an intent to defraud them. It is not sufficient that there is an intent to defraud others whose debts were in existence at the time. In Florence Sewing Machine Company v. Ziegler, it was held that in order to avoid a sale founded upon an adequate new consideration, that is, not in payment of an antecedent debt on the alleged ground that it was made to hinder, delay, and defraud creditors, the creditor attacking the sale must show two things. First, that the vendor made the sale with such intent, and second, that the purchaser participated in such intent, or knew of its existence, or had knowledge of some fact calculated to put him on inquiry. and which if followed up would have led to the discovery that the vendor's intent was fraudulent. SS 203, when question of intent res adjudicata, in Stockwell v. Silloway, the Supreme Court of Massachusetts said, to prove the intent of the defendant in making the conveyances alleged to be fraudulent in the charges filed by the plaintiff, it was competent to show other fraudulent conveyances made about the same time, and as a part of the same scheme of fraud. For this purpose, the plaintiff introduced the record of a judgment of the Superior Court rendered in proceedings between the same parties, under the provisions of the general statutes in relation to poor debtors, adjudging the defendant guilty of the charges therein alleged against him. The plaintiff asked the court to rule that this judgment was conclusive evidence that the conveyances set forth in the former case as fraudulent, and upon which the defendant was then convicted, were fraudulent. As alleged, we are of opinion that the court erred in refusing this ruling. When a fact has once been put in issue and determined by a final judgment in the course of a judicial proceeding, such judgment is conclusive evidence of the existence of the fact in all controversies between the same parties in which it is material. It is to be regarded as a fixed fact between the parties for all purposes. SS 204, intent, a question for the jury. The question of fraudulent intent is almost uniformly one of fact to be submitted to a jury, and it is regarded as error for the court to interfere with the province of the jury in this particular, unless, as we have seen, the fraud is apparent on the face of the instrument from a legal construction of it. In determining the intent, great latitude is allowed. The rule as to submission to the jury is not departed from even in strong and apparently conclusive cases. If the jury err, the verdict may be set aside. Thus, in Vance v. Phillips, it appeared that an insolvent merchant sold his entire stock of goods to an infant, who was also his clerk and brother-in-law, taking the infant's note in payment, and then absconded. A verdict of a jury, affirming the validity of the transaction, was promptly set aside as contrary to evidence. Especially will the verdict be overturned where it is apparent that the jury must have misapprehended the evidence. By statute, in New York, the question of fraudulent intent in these cases shall be deemed a question of fact, and not of law, and it was strenuously claimed in behalf of the vendee, in the recent and well-considered case of Coleman v. Burr, that there was no finding by the referee of a fraudulent intent, but that on the contrary he had found the whole transaction to be fair and honest, and that therefore the transaction should stand. The court say, however, that the referee has found facts from which the inference of fraud is inevitable, and although he has characterized the transactions as honest and fair, that does not make them innocent, nor change their essential character in the eye of the law. Mr. Burr must be deemed to have intended the natural and inevitable consequences of his acts, and that was to hinder, delay, and defraud his creditors. This principle has already been discussed in the opening chapter, but in view of the peculiar wording of the New York statute, it is deemed important to give the construction placed upon it by the court of final resort. SS 205, testifying as to intent. A party being a witness may testify as to his intention in performing an act where such intention becomes material. The purchaser may, in answer to a question, testify directly that he did not have any fraudulent intent and that the purchase was made in good faith. That it is proper to put such a question to the purchaser was directly decided in the case of Bedell v. Chase, though the contrary seems to be held in Minnesota. In Blount v. Gabler, this question was asked: had anything transpired between Blount and yourself, conversation or otherwise, whereby you gave him to understand, or whereby it was understood, that the transaction was for an improper purpose, or the purpose of defrauding your creditors? The court decided that the question was properly excluded upon the theory that it did not call for a statement of the witness as to his intent to defraud, but went far beyond this, and asked for a conclusion from what had transpired. The question was characterized as being indefinite and complicated, and as not coming within the rule which sanctions an inquiry as to the intent of a party. As a general rule, it is proper to allow the parties to testify concerning their intentions, though this class of testimony is necessarily subjected to close scrutiny when the circumstances present conclusive evidence of a fraudulent intent. No proof of innocent motives, however strong, will overcome the presumption, but where the facts do not necessarily prove fraud, but only tend to that conclusion, the evidence of the party who made the conveyance, when he is so circumstanced as to be a competent witness, should be received for what it may be considered worth. It is believed, however, not to be proper to allow a witness to testify concerning the intent or motive of another person. SS 206, proving intent. In King v. Poole, the court said, in investigating an alleged fraud, The relevancy of a given fact does not depend upon its force, but upon its bearing. Does it bear, either directly or indirectly, with any weight whatever, on the main controversy or any material part of it? Not only is fraud subtle, but that ingredient of a transaction which renders it fraudulent in fact, namely intention, is covered up in the breast, hidden away in the heart. Outward manifestations of it may be slow in appearing, and when they do appear, may be dim and indistinct. To interpret their meaning, or the full meaning of any one of them, it may be necessary to bring them together and contemplate them all in one view. To do this, one has to be picked up here, another there, and so on till the collection is complete. Great latitude is allowed on an inquiry as to the state of mind, sentiments, or disposition of a person at a particular period. His declarations and conversations are admissible. In concluding this chapter, we may recall to the reader's attention the rule that if a transaction is entered into for the purpose of defrauding any creditor, it is voidable at the suit of all creditors.